Welcome. Thank you guys for coming. My name is Aaron Thomson, and this is Becki Ashbaugh. And this is IP Your IP, or IP Your IP, which I've copyrighted myself. Today we're going to go over the basics of identifying and protecting your intellectual property, which is kind of the fundamental basics for any startup, especially here in the Seattle community. Most of the startups that I work with are based on some sort of proprietary information, some sort of copyright, trademark, patent, or other form of intellectual property. Let some people trickle in. So first, a little bit about us. Becki is an attorney at Ashbaugh Beal. She does commercial litigation, but a lot of that focuses on intellectual property. And she works with me in the corporate securities group. A lot of the companies that I represent, when I have trouble with our intellectual property, I turn to Becki for her to start throwing the blows around and to get people back in line. A little bit of a roadmap of what we're going to talk about today. A lot of the trouble that we have with our younger entrepreneurs is identifying their intellectual property, not really realizing what is their intellectual property. We're going to talk a little bit about the basics. Trademarks, how to identify them and protect them. Your basic copyrights, how to identify what you have that you have copyright in and how to protect that. Your proprietary information. Some of the things that you might not realize constitutes intellectual property as part of your business, but that most certainly does and is oftentimes the most important part of your business. And then we're going to talk about the 4 basic agreements that every entrepreneur, every startup company owner, every business owner should know. Your non-disclosure agreement or your confidentiality agreement, your proprietary information and inventions agreement, and we're going to be discussing joint authorship issues as a subset of that, your work-for-hire agreement that you would either use with employees or independent contractors, and we're going to be focusing on how in my experience, we find that people misuse work-for-hire all the time. And then finally, the licensing agreement. So we're going to start by talking about identifying pieces of intellectual property. Trademarks, copyrights, patents, trade secrets, and proprietary information. Now, the one thing we're not really going to focus on today is patents. We're not patent attorneys. We're not going to pretend to be. But patents are a very specific and special kind of intellectual property that if you have questions on, we're happy to answer those after the presentation. So trademarks, copyrights, and patents protect different types of intellectual property. As most of you know, just kind of as a fundamental, a trademark protects brand names and logos used for goods and services. You all have the NWEN logo right here on your badge. This is kind of the mark that identifies a brand to consumers so that people know exactly what they're getting. A copyright protects an original work of authorship. So when you create something of value and you actually fix that in a tangible medium, you obtain copyright protection. But as we'll discuss, that's a very limited scope of protection. And then patents protect inventions. We're going to start with trademarks, and I'm going to turn it over to Becki Ashbaugh to talk about trademarks.
So Aaron already touched on this a little bit, but what is a trademark? I'm surprised every day at work, both with my colleagues and other attorneys, that don't understand the difference between a trademark, a copyright, a patent, and other types of intellectual property. It's really important to understand the differences so then you can identify the different applications and protections that go along with each. So as Aaron mentioned, the definition is sort of any name, slogan, logo, mark, any sort of design that you use to identify and differentiate your products or services from those of another. So obviously any company could have numerous trademarks. They could have the name of their company along, for example, the Nike, and then you have the Nike swoosh, which is probably their most popular trademark. along with the Just Do It slogan, which is also a trademark. So there right there is 3 different trademarks, each of which have different value and different purposes. So as you go along and you're developing your company and you're getting new slogans and you're developing new marks, every time you're doing that, you sort of have to take a step back and ask yourself, is this something that I need to get a registration for, which is something I'll talk about in a moment. Does anyone have a guess as to what they think is the most valuable trademark in the world today? This is according to Forbes, so I'm assuming they're fairly close. It's about a trademark worth over $44 billion, just the trademark. Google, that's right, Google. So here are 4 of the top 10 valued trademarks in the world. Google was at the top at over $44 billion just for the trademark, which represented, they said, about 27% of their total net worth. So that's pretty impressive. It just goes to show you that your intellectual property and your sort of intangible assets can have the most value for your company if developed right. So why do you need a trademark? There's a lot of different reasons you need a trademark, but one of the main ones is that it allows you to develop goodwill. It allows consumers to distinguish and identify your goods from another. And more importantly, if you've poured your heart and soul into creating your company in these trademarks, it allows you to prevent others from using confusingly similar marks and sort of benefiting from your goodwill that you've taken your life savings and put into developing your company. So there's really sort of 4 general categories of trademarks that we talk about. The least protectable of which is a descriptive mark, which generally just describes the goods or services that the mark is identifying. So those are not protectable in and of themselves. They need to have what's called secondary meaning or some type of distinctiveness. So an example of that would be Seattle's Best Coffee. Obviously, it's describing the product or good itself. It's telling you it's from Seattle. They think it's Seattle's best coffee, and they're selling coffee. So there's certain distinctiveness that they have to establish with consumers before they can actually get that mark registered or recognized. Another sort of step up in terms of protectability is a suggestive trademark, which sort of describes the goods or services, but leaves it to the consumer to make the connection to exactly what the good or service is. Good example here, chicken of the sea, right? It's not actual chicken in the sea, hopefully, but they're sort of saying, we call ourselves the chicken of the sea, and then the consumer makes that connection. I got it. Arbitrary and fanciful are sort of the most unique, most distinctive, and most protectable types of trademarks. Arbitrary is you take a word that we use every day, everyone knows what that word means, you assign it to a product or service that has nothing to do with what that mark means. Good example is Apple. Another example is Grey Goose vodka. You know, Grey Goose, those are both words, but never before has it been attached to vodka. And then fanciful, which is basically you take a word that was not a word, you make it a word and you identify it with your goods or services. Another example is Exxon, Kodak, Starbucks. These are all words that we did not know until someone developed them, attached them to a product, and then we come to recognize that.
Kodak is the name.
Kodak?
What was the guy's name? Easton Kodak. Wasn't Kodak a name?
Well, it very well could be, because names by themselves are not registerable or protectable, but if it becomes something that's fanciful or distinctive, then you can register it. So that may very well be true. I know now people just think of Kodak as the word or the brand and not necessarily a person's last name. McDonald's, I guess, would be another good example of that. So protect your trademarks. Common law rights attach to your trademark as soon as you start using it. So you decide, I'm going to have a company, I'm going to call it Flowers by Aaron or something like that, and you start using that. Right away, you may have some trademark protection there, which is called common law trademark protection. But it doesn't give you the full protection that you can potentially get by registering your mark. And if you don't have a registered No problem. You'll see the superscript TM, and if someone has gone to the USPTO and obtained a certificate for the registration, then they go ahead and they can use that R. So the question always is, do I need to register my trademark? Is it worth it? It can be expensive, it can be timely, and what am I really getting? What's the benefit that I'm getting from that? And so a lot of people think that they have to go right away to the United States Patent and Trademark Office and seek a federal registration, that's sort of the only way to get the most amount of protection. And there's a couple things that go along with that. One, you can only get federal registration if you're doing business in interstates, so across state lines in more than one state. If you're a company that's just doing business in Washington, you actually can't get a federal registration, and so it wouldn't make any sense to file that application. Also, there are certain protections that come across or that come along with getting state registrations, and you can sort of, if you know you're only doing business in Washington, Oregon, and California, you could go to the Secretary of States in those 3 states, get your registration, and sort of already have secured that geographical area without needing to go file a federal registration.
I'll add that that's really important for cash-strapped startup companies. A client of ours that Becki and I just recently worked with came to us looking to get a new product that they had developed, an agricultural spray trademarked. It had this great logo, this great name, and he was all geared up to pay us thousands and thousands of dollars to get this mark used from the United States Patent and Trademark Office. Through conversations, we finally realized, hey, you're only using this in Oregon. Do you intend to use this in Washington, Idaho, Montana? The answer was no. We're going to use this in Oregon for the next couple of years. And that went from thousands and thousands and thousands of dollars in months of a long process to a $30 application fee. So it's really critical for when you're starting up your company and you're thinking about how do I spend the little money that I have, really think about how you want to protect your trademark right off the bat and what's important in terms of the scope of your business.
Yes, sir.
How does that apply to internet commerce, e-commerce? If the businesses you're doing business with are out of state and you're in state, you have to pay for all of their states or just your own?
At that point in time, you probably want to go federal. Okay.
Yeah, that's what. If you're selling to people across state lines and you're advertising across state lines and you sort of qualify as interstate commerce, then you would want to go with the federal application.
Go ahead.
And maybe jumping a little bit ahead in your presentation, but I was just curious, is there an international trademark that's recognized?
There is. So certain countries are part of the Madrid Protocol. Not all countries, but a lot of them. The U.S. is a member of that, where if you get your U.S. registration from the United States Patent and Trademark Office, you can then file to get an international application recognized in all the countries that are part of the Madrid Protocol. A lot of the Spanish-speaking countries are not, so you actually do have to locate local counsel there and work with them to try to get trademarks there individually if it's really important for you to have protection in those countries. But otherwise, as long as you have a valid U.S. registration and that stays valid, you can then get registered in the other countries if there's no confusingly similar marks there as well.
And in terms of a startup, when you're looking for investors, you're talking to VCs, you're talking to angels, they're going to want to see trademark buttoned up right off the bat. That's a no-brainer. And so you want to make sure that you've done the due diligence in terms of how am I going to use my trademark? Is this an international mark that needs to be protected outside of the United States? Is this a mark that's going to be used in interstate commerce? So that when you're making your pitch to investors or making your pitch to other entrepreneurs or making your pitch to just the next employee, you have this thing locked down and it makes sense to them. Because what you don't want to have is a bad answer to that question, is this protected? No, my $44 billion possible asset, this great brand, this great logo that I have, we don't actually have the right protection for that. And that's what you want to avoid right off the bat.
And the way it would work is you'd file your trademark application with the USPTO, and then you'd file with the USPTO as well your international application that they then forward to the international Protection Office that then disseminates it to all the countries that are part of that Madrid Protocol system. So it's possible that you would be accepted in some countries and denied by others, given what companies are already there using similar marks. Go ahead.
Do you also have to be operating internationally to go ahead and apply for that international, or can you do it, like you said, kind of using a little bit of foresight and do that well in advance?
Yeah, so as long as you have an application that's pending here and intent to use, and those countries recognize intent to use applications, you're generally okay. There's a certain period of time in which you actually have to start using the mark in commerce, and you have to file a statement of use or an allegation of use so that everyone knows that you're not just sitting on an intent to use for a long period of time. So there are time periods set up for that. So in Washington, we actually have, similar to federal trademarks, a trademark reservation right, where you can file an application here to reserve a trademark for 180 days. That is somewhat unusual. Not all states have that. So each state is different. So you'll definitely want to check the Secretary of State applications and whether they recognize something like this. But that's a unique sort of asset in Washington that lets you do that. And it's $30 per class, so every type of service or good is put in different types of classes. So you'd have to look through to determine, okay, I'm going to be selling goods in, class 1, 2, and 3. So then it would be $90 to try to register, reserve rights to use that mark with those 3 classes. And then the actual trademark registration, which has to be based on actual use, and you actually have to state what date you started using your mark in connection with all of those services, is $55 per class in Washington.
Real quick,
Yep.
on this whole breakdown of class of goods and services, when you identify the class of goods or the class of services that your mark is used for, that does define the scope of protection that you have. So for example, think of the Golden Arches. You got McDonald's. You know they're selling burgers. But you've also probably seen McDonald's mechanic somewhere in a podunk-filled town. And you're thinking, why can they be McDonald's too? Well, it's clearly a separate class of goods and services. Now, in the startup context, you want to make sure that you have the right class of goods and services and that you're broad enough to protect it. A classic example actually happened to me last week where a client of mine was interested in buying a trademark that someone else owned because it fit in perfectly with his business, which was selling these really high-end motorcycle engines. And so we did our due diligence on this trademark. It was the perfect trademark, except for the fact that the class of goods and services that it was protected for was entertainment services, which had nothing to do with motorcycle engines. So this trademark was really kind of worthless for him at that point in time, and he could buy it, but he was going to have to go through that process of making sure that he got that trademark for the right goods and services as well. So you really want to think about those classes of what you're offering and make sure that you have that locked down.
Maybe you should look at this, but so the WWF and the WWE had a trademark conflict, and I would imagine that they were in very different classes, although I guess maybe not. But do classes change or bleed over time that made that go from not being in conflict to being in conflict?
I'd have to look at that specifically, but my guess is it's somewhat describing the actual goods and services, right? The WWE and the WWF. Yeah, so go ahead.
My guess is that they had a royal rumble that ended in a settlement, is my guess. Because
No pun intended.
a lot of times you'll find that, to answer your question, do the classes bleed over? There's very distinct classes. And when you file your trademark application, you have an itemized list of classes of goods and classes of services. And you just check the box and you pay for every box that you check.
And use has to be in every class that you register for.
Right, so a lot of times what happens is people do the intent to use application and then actually only use it in, 2 of the 5 categories that they initially thought they would. So yeah, so then they allege their statement of use and just those, and the other 3 drop off at some point.
As a general matter, when you're filing your trademark, be broad. And if your services and goods are scaled down from what you filed, that's a better problem to have than the opposite.
So we've already been through a lot of these, but some of the pros that go along with state registration, to some extent it establishes validity of the trademark, not as much as a federal registration, which I'll talk about in a moment. It gives you the exclusive right to use that mark on the goods and services that you've identified within that state. It's much less expensive than federal registration, both from the application process, the fees, and if you're involving an attorney, it's a much simpler process as well. And as we talked about, if you know we have a client that does this, is practicing only in Washington, Oregon, and California, doesn't want to pay a lot of money in the front end, they just go and they get state registrations from those 3 states, and then as they start broadening their horizon, they can look to the federal trademark registration once they've made a little bit of money and feel more comfortable doing that. Some of the cons, you're obviously limited geographically. You have that 180-day period where you can reserve the right to use the mark, but that expires at some point and you actually have to use that mark. And when people see that R with the circle around it, it sometimes has a much bigger impression from a protection standpoint than just the TM, and you don't get the right to use the R unless you have the certification from the USPTO. So talk briefly about federal registration instead of the state registration, and some people do both. When you file with the USPTO, as we talked about, you can file an intent to use application or you can file an actual use application depending upon whether or not you've used the mark yet with those goods and services. But as we saw from state where it was only $30 or $55, here it's $275 per class. And that's somewhat misleading because oftentimes you're filing in 5 or 6 classes, and timesing that by $275 adds up very quickly. And then if you're having an attorney involved, there's some hours there as well. So that's why people go the state route oftentimes initially and then sort of branch out from there.
I think you'd agree it's significantly more attorney hours at the federal level. Oftentimes with the state level, you're filling out a form that the Secretary of State has given you. And it's literally check the box, fill in the blank, and your attorney can help you with it and review it. But it's going to be submitted to the Secretary of State, and you're going to have a government worker look at it, check the database, approve it. When you're doing with the USPTO, you're like fighting for this trademark, and there's someone looking at it very critically, and that's where the attorney really comes in to describe why this mark is different, why this mark is distinctive. And so the attorney hours add up quickly with the federal process as well.
Yeah, the Secretary of State will just do a search of the database, make sure there's no other company using the exact trademark that you're trying to file, and then generally will let it through. The USPTO actually assigns a trademark examining attorney to your application that does a full-blown search of all the trademarks that have been registered and that are applying to be registered with the USPTO, as well as doing the tests that we talked about. Is this just descriptive? Is this actually protectable? And then they'll come back and they'll, what's called an office action, tell you, you messed up here, we don't think this is protectable, you need to disclaim your rights to this, and they'll come back and then you get a chance to respond to that. None of that happens at the state level, so it is more time consuming, and that's why more protection comes along with it, because it has sort of a bigger and more impressive rubber stamp. So eventually, like I said, in order to get the certificate of registration, you actually have to have alleged use by that point. You can't get a registration before you've used it, and there's certain time periods set forth for when you have to allege that use. Also at the federal level, unlike the state level, once the examining attorney gives you the thumbs up, it then gets published for opposition, meaning that there's a 30-day window where someone else can come in and oppose registration of your mark, say, no, this is confusingly similar to mine. I started using before their allegation of use, and you should deny and not give them their registration. So there's sort of an open period to the public as well. Yes, ma'am.
If you filed at the state level versus federal, if when someone's filing something at federal level that's similar to what's filed at the state, would that one trump the other, or are you better off?
Yeah, so the way trademarks work is the examining attorney most likely would not come across that state registration. But trademarks are all based, whether or not you have registration, on date of first use. So if the person with the state registration started using their mark prior to the person that's wanting the federal registration, prior to the date they started using their mark or prior to the date that they filed their application, then they could come in and oppose, say, no, I'm the real owner of this mark. We're using similar marks on similar services in similar states, and I started using it before them, so you should deny their mark. Does that answer your question? So the state would not trump federal, but the date of first use could trump their application. That's correct. And there is a process set up where even if that federal registration did get registered and they did get the certificate, you can file what's called a cancellation proceeding, where if you learn about it after that 30-day window's run and after they've gotten their registration, you can still come in and start a cancellation proceeding and say, cancel that registration. I'm the real owner of this mark. I started using before them. And the Trademark Trial and Appeal Board would hear that and would rule one way or the other.
And that's just all part of policing your mark and knowing your market, your competitors. And the first step in that process is always just a very simple cease and desist order. Hey, I've had this mark since here. I've been using it since this time. I see that you now have the mark in a similar class of goods and services. You got to stop it. Or we're going to do this. We're going to go through this, and it's going to cause everybody to...
Or a phone call. There's big arguments out there about between trademark attorneys in terms of being overly aggressive about protecting marks and that sort of thing. So I'm being somewhat facetious, but...
Are there some type of, well, obviously legal ramifications, but some type of penalties or fines if you actually start using the registered trademark before you have legal rights to doing so? So let's just say you apply for the TM and, you're within your rights to use that, but you think the R with the circle looks better, so start actually using that. And unless you actually really get a lot of awareness and a lot of press, the chances are that most likely no one's going to come and call you out on it. But from my understanding, correct me if I'm wrong, you can actually get into some big trouble and actually kind of nullify some of those rights or protections that's a lot of
Yeah, just let me make sure I understand your question. If you start using the R with the circle around it before you have a registration certificate, can you get in trouble for that? Do you want to answer that?
From a securities perspective, so in the entrepreneur context, if you're using the R and you don't actually have that registered trademark and you take in money from investors, that's securities fraud. And there's everything from very stiff monetary penalties to jail time on those types of things. And so it's fraud. I mean, there's common law tort involved there, and there may be, depending on how it's relied upon and how you use it, you may be opening yourself up to a world of other types of liability. But definitely in the entrepreneur startup context, if you're misrepresenting that you have a mark that you don't, that's a big time problem.
And people do that innocently all the time. They just don't understand the difference. And so I've seen competitors or even people that work at the USPTO say, you need to immediately start using a TM. You don't have a registration for that mark. And I haven't seen them get in too much trouble. Does anyone else have experience with that issue? The R versus the TM, and if you can get in big trouble for it. I've generally seen people just be asked to change it back to the TM, and they do it. But yeah, anybody else have any comments on that? All right. So pros and cons for federal registration. Again, you can file an application based on an intent to use. You don't actually have to be using it. A lot of states don't allow that. Washington does in a limited fashion. It's deemed prima facie evidence that it's a valid trademark and that you have rights to it throughout the United States. even if you're only in a couple states. If you get that federal registration, it's puts everyone across the country on notice that you own that mark with respect to those goods and services. And there's actually a 5-year period where if no one's contested your mark and it's valid for 5 years, it becomes what's called incontestable under certain circumstances, which is a very powerful position to be in. For example, we talked about the cancellation proceeding. Potentially that would no longer be available after the 5 years. And it gives you access to federal courts, which from a litigator's standpoint is a huge advantage because federal judges oftentimes understand these technical intellectual property issues much better than state court judges. That's not always true, but because they're dealing with them on sort of a daily basis where state courts aren't, they're more familiar with the law and the case that applies to those. And it gives you enhanced damages and the potential recovery of attorney's fees if you have that federal registration. Cons, which we talked about, if you're a startup that doesn't have a lot of money, isn't exactly sure what goods or services they're going to be using or where they're going to be using them, it's sort of a very expensive process, and it can be, so people sort of opt for the state initially. Copyrights, another type of intellectual property, very different than trademarks. While trademarks is sort of your brand, copyright is what protects your ideas that you've put into some sort of tangible expression. So examples there would be, yes, sir? Domain names? Yeah, so you should always register your domain name before you file an application for your trademark, by the way, because you want to secure that domain name before you go and get your registration. Oftentimes, the URL is what you're filing your trademark application on, and so I've seen that a lot because it's either a slogan or your company name. So the answer is yes. If it's something, a mark or a logo or a URL that you're using to identify your products or services, you can register that. Yes, sir?
On that note, I mean, if you register a trademark, it doesn't entitle you to that domain name, right?
Correct. That's correct.
Not at all, right?
That's correct. And so that's why I'm saying you better make sure that you can secure that domain name before you've spent a bunch of money trying to get a trademark that then either someone else is already using or you can't get the domain name that you wanted. Make sure someone isn't cyber squatting on something that you actually own rights to, and sort of figuring out that.
They have a database where you can see if something's already trademarked?
Yes. So there's two different types. Well, there's a lot of different types. And there's actually professional search companies that do a full-blown search of all databases, both the USPTO, state, online, common law. But generally speaking, if you wanted to know if someone has federally registered their mark, you go to uspto.gov, search marks, and you can search, and you'll see both ones that have registered, ones that have been abandoned, and ones that have been applied for but haven't received registration yet. All of that will pop up. And that's part of the due diligence process before you put a bunch of time and money into branding yourself, making sure that it's actually something that's available. Yes?
What constitutes abandoning?
Good question. So several things. One would be if you stop using it for a certain period of time where it's deemed abandoned, and that point someone can come in and start using that. Another example would be is if you've filed for a trademark registration, an office action has been sent to you saying we're not going to register this. You have 6 months to respond to that office action, and if you fail to do so in that time period, then your application can be abandoned and potentially certain rights that go along with that. Well, it depends. So it can just be deemed abandoned legally if you're not using it anymore, whether or not someone else has started using it. Part of having a trademark is you have to be using that in connection with the goods and services. Well, it depends. So, I mean, I guess it's like, does a tree fall in the forest if you're not there? But no, I mean, that's a good question. Someone would have to come and say, yes, you've abandoned this to make that allegation. But at the same time, I could be like, I've abandoned my mark since I haven't used it. I'm no longer intending to use it. And, you know, I no longer claim rights to that mark. I wouldn't necessarily have to have a third party come and tell me that. It's just a legal standard. If you're not using it, it's deemed abandoned. Yes, sir.
Well, we're often hearing stories about small companies or
Yeah.
And the explanation is always that, well, we need to defend our trademark.
Yep.
We have to do this. We have to go after the market. Is that true? Do you have to, if you're a company with a trademark, are you required to go after these companies and threaten to sue them to protect their trademark?
The answer is the more companies that are using a similar mark to yours throughout the country, the strength of your mark goes down. It's diluted. It's potentially not as protectable. Do you have to do it? No. If it is a company that you're a direct, indirect competition with that potentially is getting some of your competitors and there's some confusion, it is a good idea. I don't know how many of you listen to 950 KJR at all. Mitch in the morning, he had what was called the bigger dance. Does anyone watch this? No? Okay. Well, yeah. So you know how you have, in March Madness, you have the big dance and everyone fills out their brackets on which teams are going to win the NCAA tournament. He had a radio show where he had the bigger dance, and it was the same idea, and it would compare women when you would vote who would go on to the next round. And he gets a letter from the NCAA saying, you're using bigger dance in connection with this game is infringing our trademarks for the big dance or the dance. It's just an example where they're trying to claim their exclusive rights to use that with anything that's similar to keep protection.
That's kind of the litigation side of your question. There's a corporate side answer to your question as well, and that's if you're a director or an officer, if you're a fiduciary, if you started a company, a corporation or a limited partnership or an LLC, and you have fiduciary obligations to your shareholders, policing that mark is part of that. And if you know that, I have this brand out there and I'm selling this product, and all of a sudden there's another competitor on the market using a very similar trademark, diluting our brand, diluting the quality of our product, and causing consumers to mistake our product with theirs, you have a duty to your shareholders to police that mark, because they invested in your company based on having that mark. And so that's why they often say, we have to do this, because they're answering to their shareholders and their investors. And that's a kind of just a subtle nuance of why companies say they have to do it. It's actually the board of directors holding up their fiduciary obligations.
I guess where it comes in and where it kind of rankles the public is when the case happens where there is somebody that has a name for a long time comes in, and it might have been Apple something, because Apple does this. They will file something, and you're this small business owner being
bullied. Yeah.
And so there's I guess the question of provision for for a small company. What are you supposed to do? You basically give up. I gave up a domain name because of that, because I just didn't want to deal with it.
And a lot of times, the idea for those companies is if they are a big company policing their marks, it's the fact that they know small companies who have a budget probably don't have $50,000 to put into a lawsuit over this trademark. And so, yeah, it's the cost of justice. And they kind of use that, they swing that around fairly or unfairly. But
And to just give you one more example, we had a client that was called Creature, and there was another company that was called New Creature that we were trying to have them say, this is confusingly similar, and we raised those issues. And New Creature then pointed to all these other companies that had Creature in their name and saying, well, all these other companies have Creature. The marketplace is clearly adjusted. There has been no actual confusion. Everyone knows that Creature isn't distinctive, yada, yada. So it can be something that can be used against you if you ever decide that you want to enforce your rights. If there's a bunch of people that have a similar name and sort of consumers have adapted to it, it decreases the argument for likelihood of confusion and infringement, if that makes sense.
if there's more trademark questions afterwards, we're going to be staying for office hours afterwards. So
Office hours.
feel free to-
So,
That's what they call it.
yeah. Brings back horrible memories of law school. Okay, so copyrights. quickly. This is different than trademarks. This is something that you're creating and putting in tangible form, whether it's a book, whether it's songwritings, a photograph, a design, a drawing, something along those lines. What we're seeing a lot now is software and computer code, copyrightable, and issues that come up with that we'll talk about. And it just begs the question, everything that you're putting down in tangible form, is it something that's unique? Is it something that's original? Is it copyrightable? And then should you put the little C by it, and what does that mean? And do you actually want to try to register it with the U.S. Copyright Office?
Now, when we talk about fixing an original work of authorship in a tangible medium, that can be as simple as writing that awesome idea down on a cocktail napkin. That is fixing that idea. And if it's an original work of authorship, you fix it in tangible medium. You have limited common law copyright in that idea, just on that cocktail napkin. When you record a song, or when you've come up with some sort of idea, put it on paper, record it, videotape it, get at least that basic copyright right off the bat.
So some more examples, obviously stuff that's on your website, newsletters potentially, anything that's in written or tangible form. Yes?
Question. I've heard that if you have an idea, you can send it in the mail and mail it to yourself. Is that something that's
That's kind of this old wives' tale where you postmark it and send it back to yourself as a date to fix it in a tangible medium. But there's better ways to register it, and there's better ways to fix the date. But that, in the early years of copyright, that was kind of this whole idea of how do I fix it in a tangible medium and slap a date on it for the world to see. And that's kind of...
And now you just email it to yourself. It's much easier now. It gets there quicker, too. So as Aaron mentioned, same with trademarks. Copyrights are automatic protection. In terms of the second it's created, it's copyrightable, and there's certain protection that goes along with that, whether or not you have a registration. And unlike the R in the circle, the C you can use immediately. You don't have to have a registration in order to do it. So if something's important that you've fixed in tangible form, you want to put everyone on notice that you're the owner and that it's copyrightable, you would put that down with the date and the name of the company or person that owns that copyrightable material. And this is so if you ever do get in a dispute, you have this to point to that everyone was on notice. If they found it on the website and it has the C and your name and the date and they've copied it, it's a pretty tough uphill battle to prove, for them to prove that it was innocent or that they didn't know that you were claiming to be the owner or that it was copyrighted. So the bigger question is, do I need to register my copyright? For whatever reason, when it comes to trademarks, people seem to be a little more sophisticated on that end. Know what the USPTO is, know that they need to get a registration, whether it's state or federal, and move pretty quickly. Copyright, there's also a lot of benefits to registering your copyright and to do it quickly. And so while you have an enforceable copyright, you may need to register to get certain rights. And that's done not at the USPTO, but at the US Copyright Office. And so some of the benefits are that obviously it gives you a public record of the copyright claim. People can do searches on the U.S. Copyright Office. They don't get access to your entire copyrighted material, but they can do searches for certain titles and those sorts of things to see if something has been filed. And perhaps most importantly, if you register within 3 months from the date that you sort of first publish your work, it's deemed to be prima facie evidence that it is copyrightable, that you're the owner, and that it's a valid copyright. And a lot of people don't act quickly within that 3 months, and then they find out someone has infringed, and they've lost certain protection and certain rights to damages and to attorney's fees because they didn't move quickly enough. And then the interesting thing, unlike trademarks and copyright, you actually have to have filed an application with the U.S. Copyright Office in order to sue for copyright infringement under the Copyright Act. So a lot of people end up filing their lawsuit, alleging copyright infringement, and sort of have to dismiss and then refile after they've filed for the registration, which is an unfortunate amount of attorney's fees being spent and time being wasted.
And when you're thinking about protecting your intellectual property, registering a copyright is really critical in allowing you to cost effectively protect your intellectual property. The whole idea of having to enforce your rights against someone who's infringing on them, but at the same time spending tens, if not hundreds of thousands of dollars doing it, that's just, you lose in the end. The bottom line doesn't work out. The attorney's fees is a really important aspect of this where, you know, if you have to sue somebody to stop infringing on your rights, they're going to be on the hook for your attorney's fees. And that's really important when the bottom line is, you know, a little bit closer than you want it to be.
A lot of times what happens in these intellectual property disputes is someone files a lawsuit and they haven't gotten the protection in the front end to give them anything other than an injunction from the court saying, hey, okay, yes, this is a technical infringement and you can no longer use this. But they're out their attorney's fees, they're out any potential damages because they weren't able to prove damages, and they don't get the presumption of damages because they didn't file early enough. And at the end of the day, you've spent 50 grand just to have the court say, don't use that anymore, which sometimes is a big, great success, but it would be better if you actually got the damages you've incurred along with your attorney's fees. That's sort of the home run, and you can lose even arguments to those things by not filing immediately. Good question. The answer is you can file both. Depending on what it is that you're trying to protect. But yeah, the computer code and the software can also be filed. And that raises interesting author questions and owner questions that I'll talk about in a little bit. But yeah, you definitely want, because some people could get potentially the same output with different code. And if you've filed your code and then you get access to their code and you can prove that their code is similar to your code and it's clearly been copied, that's more powerful than just being able to show the two websites are similar.
What constitutes a unit for copyright? Because, you know, you see a copyright symbol on every page in a website. Is the entire website copyrightable with one filing, or do you need to copyright every screen view? And it's very messy because of the way the web works.
Well, yeah, and it can get messy. When you file for copyright, you start with whatever you consider to be that original work of authorship. So if you write a book, you would copyright that entire story, that entire book that you've fixed in a tangible medium. If you have a collection of short stories from different authors, each author has copyright in their story that they contributed, but you compiled them and you made that book. You have copyright in that book. It's very interesting how those copyrights overlap. I have copyright in the overall book, but each individual author still retains copyright in their particular story that is compiled. So it's done messy because people don't understand exactly how to use it properly in most cases, and there are overlapping rights. Another great example is a great songwriter writes a song and performs a song. He has copyright in that song that he wrote. Then the recording company comes in and says, hey, we want to sign you to a deal and we're going to record this song. You go in there and they record the song. It's usually the recording company that has copyrights in that recording that ultimately makes it onto the album, even though the songwriter has copyrights to the song, the underlying song. So it really is an overlapping set of rights, and it does become a mess, and that's why we usually resolve that mess with agreements, and we're going to be getting to those shortly, kind of in the next portion of the presentation.
And just to answer your question, you could potentially register everything that's on your website. You could do it individually or potentially as a compilation, but there's a specific circular that the U.S. Copyright Office has issued exactly on that issue because people are very confused when it comes to website and website content on what's registered, what's not, how do I do it. And it gets pretty complicated, but there's a lot of literature on it and a lot of explanation for how you would go about doing that.
Is copywriting code put into the public domain?
Pardon?
I couldn't hear the question.
Is copywriting code put it into the public domain?
No. So in other words, would people have access to that code? No, and that's important. So some people think that because you actually have to submit a copy of your work to the Copyright Office. And no is the answer to that. But if you get in a dispute or a lawsuit, you potentially would, the U.S. Copyright Office would potentially have to produce it at that point. Also, if, obviously a court order or something like that, you can gain access to it that way. But generally speaking, the public cannot request a copy or go online and find it or something like that. Yes?
Is it true with software code that you don't have to submit the entire code, you can submit a portion of it?
Yes, that is true, but sometimes you want to make a record by submitting the whole thing, if that makes sense. But yeah, I mean, some code, is so long that you can do certain portions and gain protection that way and describe the rest.
Okay, we're going to move on to the next type of IP, which is proprietary information. When I think of proprietary information, the first thing that comes to my mind is trade secrets. And this is kind of the guts of how your business works. Formulas, practices, processes, designs, instruments, patterns, compilations of information, techniques that are not generally known or reasonably ascertainable. And you use those things to gain an economic advantage over your customers. I think of this as your secret sauce. Why is your burger good? Why do people come to your store for your burger? Because of your secret sauce, your proprietary information. So the Uniform Trade Secret Act defines trade secret as information where reasonable measures have been taken to protect that information, and you derive independent economic value from that information not being publicly known. Now, you can understand that information covers such a large scope of things. So what are we really talking about here? Well, when we're thinking about trade secrets and information, I'm talking about your customer lists, your trading methods, your marketing strategies, your contact lists. I mean, your Rolodex in some cases. And how do we protect these things? Well, we start by taking security measures. As you remember, you got to take reasonable measures to protect the information. So, for example, how do you collect your customers' billing information? How do you protect the information that your employees have as they work for your company? How do you protect the information that you license out to all of your customers and clients? You want to think about the security measures that are available to you to protect your information. When in doubt, label something confidential. Put the stamp on it. If you don't want an internal memorandum to be sent out and used by your competitor, label it confidential and take measures to protect it. Because if that internal memorandum has really important stuff in it that's going to give you the economic advantage to beat your competitors in the market, that is proprietary information. Those are trade secrets. Those are protectable. So we've talked about trademarks. We've talked about copyrights. And I've identified to you what types of things are proprietary information, trade secrets. Now we're going to kind of switch gears and talk about what you guys can do as business owners to protect these things. And there's really four basic agreements that every entrepreneur, every startup company needs to know about. Your NDA, your PIIA, your work for hire agreement for independent contractors, which is usually just your independent contractor agreement, and then your licensing agreements. So we're going to talk about non-disclosure agreements first. What's the purpose of an NDA? Well, when you're talking with someone ready to do business, your NDA is going to identify what your confidential information is. You're going to describe it. It's my copyrights, my trademarks, my patents, all the underlying intellectual property therein. It's going to be my notes, my Rolodex, my customer lists. And you're going to get a document that says, I'm going to share this with you for limited purpose of doing business with you. But you can't share it with anybody. And if you do, it's a breach of this contract. It protects your confidential information, but it allows you to open communication channels. Because if you think about it, when you're an entrepreneur, you have a startup company, and you've got this great code, you've got this great secret sauce, you've got this great idea, you're so worried about it being stolen, when put out on the market, put into the public domain, you're probably just going to sit there paranoid and keep it to yourself. You're never going to make money doing that. You've got to get your ideas out. So using an NDA opens channels of communication, and it promotes business.
I've heard a boatload today about how no one wants to sign anything.
Of course not. People want to be able to use your confidential information. You'll find that people who are normally used to dealing in intellectual property, people who are normally used to dealing in copyrights and trademarks, they understand that if they have those types of things to protect, you probably do too. And so if someone doesn't want to sign your NDA, there's usually a reason behind that you want to flesh out. Now, it may just be because they want to hear all about your business, and they just want to get, feed off what you have to give them, so sponge up your information. It may be because they don't want to inadvertently disclose your information and be in a breach of contract situation. There's multiple reasons someone wouldn't want to sign it, but there's more reasons why you would want someone to sign it. And when you're dealing with people in the business world, there's really three times to use it. If you're going to engage a new business relationship and you're going to be exchanging confidential information as part of that relationship, it's usually appropriate to start with an NDA. And in my experience, our clients use NDAs all the time successfully without any hassle, because usually the other side is wanting an NDA as well. Every time.
One of the main places they come up is if you have a really great idea, but you're not a software engineer, you don't know how to build the website, you hire someone to do that for you. In this market, in this day and age, if you're paying them to do that work, they're more likely than not going to be willing to sign an NDA, because there's going to be someone else that, if they're not, is willing to sign that thing in order to get money and get paid and help you bring this thing up. So generally, we find that as long as both people are good people and are in it for the right reasons, we can come to a place where everyone's comfortable.
I heard that it's very, very difficult, if not impossible, to get private equity firms to actually sign an NDA. It's because they see a lot of, they hear a lot of pitches, and they see a lot of different startups.
Sure, and at a certain level, it becomes appropriate for them to do that. Maybe not right off the bat when you're giving your first look forum pitch. You're just generally describing your business model. You don't need an NDA at that point. But at the point in time when you're seriously talking to investors who are looking to put money into your company, and you're going to be showing them the guts, the nuts and bolts of what you do and how you do it, absolutely you want an NDA. And if they're not willing to sign it, that's usually a major red flag. And we've seen that happen. We've seen companies that they engage in this whole due diligence process, and they're throwing out big numbers and big, the term sheet, and at the end of the day, they walk away. And why do they walk away? Because they've learned everything they need to know about what you do and how you do it. Now, one of the ways to get around that is...
Just so everyone knows, we're right at our time that we're supposed to be done. We're happy to keep going, and if people need to leave, they can leave.
Well,
but
we have office hours built into 4:15. Dan Shapiro speaks at 4:15, I think. So
Maybe you could do your presentation and save the questions for after. So
yeah,
Sure.
That's a good idea.
Sure. So just to kind of keep going where we were, the one way to get around that, I've found, is to offer them a mutual NDA, one that works both ways. If we're going to be talking about doing business together, I'll keep your information confidential, you keep my information confidential. We're both held to the same standard. And if people aren't willing to do business with you on that level playing field, they're usually trying to milk you for your information. And that's what I've seen it happen to too many good people who had too many good ideas, and they were just too trusting right off the bat. If they're not willing to say, hey, let's keep this confidential both ways, it's usually a red flag. Also, a lot of times, people start off with a one-way NDA, which says, hey, let's talk about doing business. Protect my confidential information. A lot of my clients have been foolish enough to sign those. They think they signed an NDA that protects everybody. They walk in, they spill the beans, they open the kimono, and the next thing you know, they realize only the other person's confidential information was protected. A lot of times, there are specific provisions that are required when dealing with international companies. You want to make sure you're binding them to the right conventions and treaties to make sure that they are going to respect your proprietary information and the protection thereof. When you're talking about an NDA, the key provisions in this document, and each one is going to be tailored specifically to your business, and there's no good form. You can't really find a form on the internet that I would be comfortable with anyone just taking off and running with. Your definitions are really important, because your definition is, what is my proprietary information that I want to protect? What are my trademarks? What are my copyrights? Make sure you encompass everything so that when you share it, it's protected. Make sure the restrictions are laid out. Can I talk about this after 3 years, 5 years, 2 years? Can I talk about this to my other limited partners? Can I talk about this to the other people in my fund, the other VCs? I usually like to put a trade secret provision in where both parties agree that any information shared actually constitutes a trade secret, which allows us to access the USTA statutes on injunctive relief without having to post bond. You can just get them to stop by suing under the Trade Secrets Act. No license. This is a big one in your NDA. If I'm sharing information with you, I want to make sure that you know I am not granting you any type of license to that information. I'm giving you this information for a limited purpose of trying to figure out whether or not I want to hire you, whether or not you're right for the job, or whether or not we want to do business. I'm not granting you any type of license in any of my copyrights, my trademarks, or anything. And then there's obviously the non-compete and the non-solicitation. You can't take my information and go out and compete with me, and you can't take my information and go out and solicit my customers, or even solicit my employees, or my independent contractors, or my vendors, or whatever. This document just really sets the boundaries of, let's be truthful right off the bat. It's an important way to do business. If you're finding that people don't want to sign them, there's usually a reason, and it's good for you to ask that question. Why don't you want to sign it? What's behind that? Proprietary information and invention agreements. This is, it sounds like it's a monster, a Frankenstein of a document, but it's actually really simple. And what is it? Well, it's the document that you use traditionally with the people inside your company to make sure that everything that's created by the people in your company is owned by your company. Great example, Microsoft. How many thousands and thousands of employees does Microsoft have writing code, coming up with new ideas, new logos, new brands, new systems, new operating systems, new software? If every little employee that comes up with that stuff from Microsoft owned it themselves, they'd just leave Microsoft and Microsoft wouldn't exist. So the PIIA is what we use for Microsoft to say, hey, if you're working for me, we own it. So what it does is it essentially protects the IP as it's developed. It sets the terms of the relationship right off the bat. It also protects business opportunities as they're developed. It requires your employees or your independent contractors or even your shareholders, depending on who they are, what size of company, and how you're structured, you're required to bring that opportunity to the business. Bring that confidential information to the business. Yes?
As a practical matter, how does, on the litigation end, how is that enforced? Since obviously a ton of people do, is there a rebuttable presumption that if someone at Microsoft comes up with a cool piece of software, leaves Microsoft, starts a new company, I mean, how does Microsoft get to enforce that? Because it seems like that probably happens all the time.
It does happen all the time. And so with PIIAs, and you're jumping ahead one slide for me, but the way it works is when you have employees who come to Microsoft, what you say is, general rule in the contract, everything you do as an employee for me belongs to me. If you have any inventions or great ideas that don't have anything to do with your employment, tell me now and list them here, and we'll exclude those. And there's actually a statute that we're going to talk about in a second that requires you to do that. But the way it works in Washington is if the employee is using knowledge from work, or if they're using, you know, for example, if they're using their work computer, or if they're using skills or information that they've gotten from Microsoft, code that they've gotten from Microsoft, that is the rebuttable presumption that it's a work for hire, that it's owned by the company. What we're doing with the PIIA is we're just going around it and saying this is now just straight breach of contract. You've signed a contract that says everything you make working for me belongs to me. And maybe you're not big enough to have employees. Maybe your company is just 3 shareholders. And the 3 shareholders are all creating code. You're all coming up with business opportunities. Maybe one guy's the code guy, one guy's the design guy, one guy's the marketing guy. It's a great idea to have one of these in place with everybody so that they don't say, well, you know, what I was doing was really on the side just for me, and I'm going to take this and run with it on my own. You want to make sure that everything that everybody's contributing to the company is actually owned by the company. Otherwise, you have no valuation. Your company's value never grows. No one's going to want to invest, and the thing never blows up.
Your question fits in perfectly with what we were just talking about, in that if you're on top of your IP, as soon as your employee is creating a valuable piece of intellectual property, whether it's a trademark or a copyright, you would then attach ownership to that by maybe filing an application in the name of the company to get a registration saying that the company owns that piece of intellectual property, and establish it that way. We see oftentimes where people just don't really think about it and they get trademark registrations or copyright registrations in their own name or someone else's name rather than in the company name, which then we have to do an assignment agreement or something like that. But it is something to take very seriously. When you're saying who the owner is, make sure it's the right entity.
So in my work, I have an agreement, and that's pretty clear. But I know that universities also often exert some claim, but I don't know when the agreements are assigned.
Universities?
Yes. So if I come up with some invention during the course of my own dissertation research at university.
Yeah, that's true. And a lot of times that becomes a subject of a contract negotiation that usually ends up in a settlement agreement between the university and the person. But a lot of times if you're doing something for course credit, there's going to be a presumption of ownership.
So there is a presumption even though there is maybe not assigned.
Yeah, the law gives presumption. And in the case of an employee, under the Copyright Act, you have what's called work for hire, and you have a presumption that the employer owns it. But not everybody is actually an employee. Not everybody, you could just be a shareholder, or you could be an independent contractor. Key provisions in your proprietary information and inventions agreement. Again, the most important thing is the definitions. What are you building? What is the business of the company? What is the intellectual property? What are we talking about here? The second most important provision is the assignment. The employee, the shareholder, the independent contractor assigns in express language, I hereby assign all my right, title, and interests into anything I create while under your employment to the employer. That language is critical. A non-compete, I'm not going to take this stuff that I created, go out and compete. I'm not going to go out, I'm not going to take this information and take the 3 buddies that I have in this department and go out and hire them for myself. The RCW 4944-140 notice has to go in every single document. And what this is the idea that the employer cannot make you sign the entire world. If I'm working for Microsoft and I'm doing code for Microsoft, they cannot make me assign the rights to this great novel that I'm writing on the side. And there has to be a statutory block of language in this contract that says, hey, if you have other stuff that's unrelated to this employment, you got something going on the side, let us know. And if it comes up next year, let us know. That gives the employee the right to go out and still be creative and an entrepreneur on his own. Injunctive relief is always important because you just want to be able to go to the courts and say, make them stop. So you always want to agree to that. And the other two are pretty self-explanatory. Becki, do you want to talk about joint authorship?
Yeah, we've talked about this a lot, but in the things we've been talking about today that are protectable from trademarks, copyrights, What we haven't mentioned is just a great idea you have or something in your head. It actually has to be something that is protectable. And sometimes people don't really understand that from the standpoint, if you're meeting with a web designer, a software designer, and you're spewing to them all these great ideas that you then want them to fix in tangible form and create the code and give to you to use, technically without an agreement, they would be the owners to that copyrighted material because they're the only ones that have now fixed it in tangible form and made it protectable. These ideas that you've been giving them, that they've been taking notes on and creating, that's all great, but you've just handed them the key to unlock the door to create something that they protect. This happens a lot with joint authorship in terms of people after the fact argue about were we co-authors of this code, were we co-authors of this book, or were you the sole author? And yeah.
Is that the exact thing that happened with those twins in the Facebook?
Did everyone see that movie? Yeah, no, that is if we haven't learned from Facebook that having agreements up front is very important. You can see that when something blows up, if you haven't dotted your I's and crossed your T's, it is a huge loss. But yeah, that is exactly what happened. He took it and he ran with it, and all they had done is given him a really great idea that wasn't protectable, and he hadn't signed any sort of confidentiality agreement or otherwise. And the reason this is so important, I'm going to skip to this slide, is that if you are determined to have been, if someone is a co-author in your work, whether they gave 1% and you gave 99%, you both own that work, you both have rights to license that work, and you both have to account for profits to each other 50-50, even if you only gave 1%. Now, obviously, you can contract around all of that, but you could see how this would play out. Someone maybe contributes just a small section of your code, you've done the rest, it blows up big time, and they take it and they start licensing it to other people, earning money, asking you for 50% of the profits because you didn't get an agreement in place prior to going down that road. And the worst case scenario is what you just spoke about on Facebook, in that it was your idea and you can't even show that you were an author. You don't even qualify as any part of the owner, and in fact, you're 100% out of the mix, and they're the owner, and they can run with it and do whatever they want. So this is part of what Aaron's talking about, both in the PIIA and the work-for-hire agreement. And we unfortunately have clients that have dealt with this all the time, where they're the ones sitting in the desk or in the office telling the code writer or the book writer their ideas without any agreement in place. They then get written out of the story and don't have any legal recourse to claim that that's their work. So, yeah, I already mentioned this. If you qualify as an author, each has the right to license or use, and you have to account to the other. And it's important because if you're an author, you have to show that what you contributed was copyrightable in and of itself. So, absent some sort of agreement to even gain rights as a part owner or a part author of a copyrighted material, you have to show that what you contributed was important, that it was original work that's copyrightable.
Okay, I'm going to speed through this because we're really going over time here, and I apologize. So, work for hire. This is really just kind of a warning. I hear, in my practice, I hear work for hire thrown out all the time, and I'm sure you guys have heard it too. But when you go to the source of the law on what work for hire is, it's not really what you think it is. So, yeah, it's any work prepared by an employee within the scope of his or her employment, but if they're not your employee, if they're your co-founder or your limited partner or an independent contractor or another shareholder, it's got to fit into this weird definition. A work specially ordered or commissioned for use as a contribution to a collective work, like a motion picture or audio-visual work, a translation or a supplementary work, a compilation, instructional text, test as an answer material for a test or an atlas, or if the parties expressly agree in a contract that it's a work for hire. So really, a lot of times I hear people say, "Oh, it says in the contract that it's work for hire. It's good." But a lot of times we find that that actually doesn't hold up. And so what we really want to do when you think of work for hire, always assume as a starting point, and maybe this is just the paranoia I've gotten from my experience, is that you can say it's work for hire, but you need to go one step further. If the parties have an understanding that it's supposed to be work for hire, there should be an assignment of all right, title, and interest. And those are the magic words. Because relying on work for hire is going to leave you shortchanged more often than not. Because this is a weird definition. This is a weird kind of universe to be boxed into. And if you have people doing important stuff for you that are not technically employees, you're going to want to make sure that that work is assigned to you and not just some understanding that it's work for hire. So work for hire is a very dangerous term to be throwing out because it's often misused, misapplied. And so what I'd really like to, if I can leave you with one message, it's that extra step of assignment is really critical in protecting your IP.
One last comment on that. Work for hire agreements actually have to be signed before the work is commenced. So that makes it even more important to have an assignment language in there, because the only way to transfer the rights, if someone has already started the work, already created the work, is to assign it to whoever its true owner is supposed to be. So you can cover both bases by doing what Aaron's saying.
And the danger comes from, this is a Supreme Court case, 1989, and it's very clear. If you use independent contractors, which a lot of startups do because they can't afford to have a huge employee legion doing all the dirty work for them. What do? You outsource. You get people to help build the code or build the website. When you're using independent contractors, there is no such thing as work for hire unless it falls within one of those specific categories. So get a written agreement. Get an express assignment of rights. It's just critical. Finally, license agreements. What's the purpose of a license agreement? It's to turn your intellectual property into money. Turn this thing into a business. It's to define how your intellectual property is used by the public, limit who uses your intellectual property, and control how it's distributed. When do you use it? Well, you use it once you have intellectual property to put out there on the market. You use it when you need to take in other people's intellectual property to help yours. For example, you have a business. You need to bring in other software. You need a license to use that software. Or maybe you need a license to a specific part inside of your widget. You got to get a license. And you got to make sure that license gives you the right to do exactly what you want to do with it. When you mutually share IP, you want to make sure that it's licensed and not jointly owned. Again, when you compile or integrate intellectual IP, as in bringing in someone else's software, someone else's code, or someone else's component to your widget. And as just a bottom line, use it as whenever you can when you're dealing with intellectual property. Always use a license agreement to protect how it's used or what your rights are in someone else's intellectual property. When we're thinking about license agreements, these are the really most important point is think about what the license is. And when we think about a license, there's some basic categories. Is it a limited or an unlimited license? Am I going to put restrictions on how this person uses my software or how they use my code or how they use my widget? Or am I just going to give them an unlimited license to do whatever they want? Is it assignable or not? If I assigned you the right to use my software, can you turn around and sub-license it to somebody else? Is there a geographic restriction on using my software or my intellectual property? Can I revoke the license, or is the license irrevocable? Obviously, there's royalty-free and fully paid licenses. Do you need to pay me monthly to use my license? Do you pay me one time to use my license? Am I giving you the rights to this for free? And then really the most important two things are define what the license is. The license to do what? If I have software, am I giving you the right to use my software in your business? Or am I giving you the right to use my software but not make money off of it? Am I giving you the right to use my widget in your home? Or am I giving you the right to use my widget out in commerce and to turn it into a business of its own? What are you doing with that license? And so when you have a company that's built off intellectual property and you're trying to turn that intellectual property into money, you really have to think about how do I want to restrict consumers and customers in the way that they use it? how do I want to license this stuff out so that I still own it, but other people can use it and I can make money off of it? And then at the end of the day, once you've defined what your license is, make it very clear that you reserve all other rights. Have it in writing, have it in a contract, protect your intellectual property, lock it up as tightly as you can. Kind of the final thing I would say is it's a lot more, and I say this at the end of every one of my presentations, as Annie knows, but it is way more expensive to pay your attorneys to be janitors and to clean up your intellectual property mess than it is to pay an attorney to be an architect and make sure it's built correctly the first time. So when you're thinking about your license agreements, your NDAs, your PIAs, your work for hires, it's so much cheaper to talk to somebody about, hey, does this work for me? Does this fit my business model? Am I licensing the right way? Am I protecting my intellectual property? Do I own the stuff that my employees are making? It's so much cheaper to do that up front than at the end of the day say, I need to hire you to sue these people because I don't own what I think I own, or they're using it in a way I don't want them to. So pay us to be architects, not janitors. The time for the rest of the day is free. Thank you.